Good morning, international officers, delegates, guests. For those of you who don't know me, my name is Kevin Marrinan, General Counsel to the ILA, together with our colleagues Andre, Elizabeth, John, and Leslie. And we're very pleased to have this opportunity to address the convention, and I want to focus on some recent changes in the law that affects all the members at the convention, and it's specifically focusing on an area of the law called the duty of fair representation. So what I'd like to do is briefly describe the duty, explain the recent, what seems to be the change, explain why it should concern you, and what steps you can take to make sure yourself and your local are protected going forward. The duty of fair representation is what they call a judge-made law. So it was really recognized by the courts by virtue of the fact that you, as locals, have a duty to represent, as the exclusive bargaining rep, all members of the collective bargaining unit. So what that means is you have a duty, both, especially in the South, to represent non-members who are members of the unit. And you have that duty with respect to negotiating, enforcing the contract, and if you're running a hiring hall. So those three areas is where, and it's pretty much, that covers everything you do. So let's just focus on the second one, because that's where we seem to be seeing the change. Most DFR cases involving administering the contract involve processing grievances. And here what happens is the union may fail to take the grievance at all, just doesn't process it, may process it in a perfunctory manner, and by that what I mean is maybe you don't interview witnesses, maybe you don't get the documents, you don't really investigate it before you get to the grievance hearing, or you settle the case short of arbitration. Those are the three type of cases we have. There's a landmark case by the Supreme Court where they laid out what the duty is. And if you see the case, you'll see it's 1967, and the law hasn't changed since then. So what they say is, you don't have to be negligent, it's a higher burden. To violate the duty, you have to be engaged in arbitrary, discriminatory, or bad faith conduct. Negligence is not sufficient to state a claim against you. You don't breach the duty if you settle a case short of arbitration. You have that right because you know the contract and you know the strengths and the weaknesses of the case. The court isn't going to second guess you on that. You can refuse to pursue a grievance for a variety of reasons, but you have to have a reason. And what I always say to people is focus on the grievance, not the grievant, because sometimes there's a temptation if the person is that type of person, or it might irritate you, or it might be just the person who comes in all the time. You focus on them, but you got to focus on the grievance. Does the grievance have merit, and is it worth your time to pursue it? If you focus on that, the courts will always defer to you. So why am I talking about a case that's over 50 years old? And I'm doing it because the National Labor Relations Board seems to be changing the law. And that's important because if a person alleges a breach of duty of fair representation, they can either start a lawsuit in federal court where they have to hire their own lawyer and pay him, or they can go to the NLRB and file an unfair labor practice charge against you, and the board will do their legal work for them. So the board is changing the law, and the concern you should have is that it's making it easier for grievance to file charges and proceed against you. The board's general counsel just provided the regional offices with new instructions on how to handle charges against unions in DFR cases. Now, the regional directors, they're like the prosecutors, they're like the DAs. That doesn't mean the board itself, the 5-member board, is going to adopt it. So right now, this is just what they're suggesting. But they're telling us, they're sending you a sign. We're going to look at it differently than the courts. So you have to expect it's going to be adopted by the board, but you also have to anticipate and say, how can I protect myself from this new type of case that might be brought against me? So how does this new case change the current treatment? Well, first off, no one's pretending it doesn't change. The General Counsel's office admits the new approach, and this is the quote from it, may be inconsistent with the way the board and regional directors have historically interpreted the law. So they admit they're changing the law, and they're doing it to create a new type of liability against unions. They're going to make it easier to file charges and hold you liable. In particular, the board said it's going to focus on two types of cases, what they refer to as a forgotten grievance, a type of grievance or where a person may have said, look, I intended to file it, I filed it, and for lack of a better way, it might have fallen through the cracks. Or where a union doesn't communicate with its members regarding the status of a grievance or doesn't respond to their inquiries. And the latter one is especially dangerous because it doesn't really focus on whether or not it's a good grievance. It's just focusing on you and are you keeping the grievant informed as to the status of the grievant. So how can you avoid these charges? There's three things that I point out: education, record keeping, and communication. In terms of education, you got to be familiar that there's going to be different standards, it looks like, in the board and the courts. Anticipate people are going to go to the boards. If you want a copy of the General Counsel's memo that you can provide to your own local council, please feel free to come by our office. Another thing you might want to consider is, remember yesterday the president of ULICO spoke. You can get fiduciary and liability insurance for DFR claims. And for those of you, think of it this way, I always look at it this way. Let's say you're on a trust fund, you're a trustee, you have fiduciary and liability insurance. If you don't have insurance as a local officer, where do you think you're going to be more likely to be sued and have exposure, as a local or as a fund? So it's worth looking into. I'm not trying to sell it, and I'm just saying look into it. If you want to come to our office again, we'll try to explain what you should look for, but it's something worth considering, especially because the board is telling you they're going to bring more charges against you. Now, the so-called forgotten grievance. Here, if the charge is filed against you, you're going to get a call from the board. And what they're going to look for, or what they're going to ask is, do you have an established system in place to track grievances? The old mere negligence defense that I just forgot about it, or we got busy, we were negotiating with, will fail. You will have a chance if you have an established system in place, but you have to have something. Now, I've been speaking with the counsel for the district, Eric Nelson, and our office is going to try to put together some type of system that may or may not be helpful to you, and we'll happily share it and make it available to you. But you got to have some system in place. That's what they're going to ask you for, because you can't get around it. One grievance fell through the cracks. So the answer is, do you have a system? If you have a system, you may be able to avoid liability. But if they call you and ask you, do you have a system in place, realize they're doing it for a reason. So what's the type of system you should have? Have a system where these matters are covered. You know the contract time limits for filing grievances. You keep the member informed about the status of his grievance. Keep a written record of dates, decisions. Allow the member an opportunity if he wants to submit additional evidence. And when you make a decision, if you decide to settle the grievance, drop it or whatever, inform the person. And it's probably better to inform him in writing. And the reason I say that is it's a short time that they can go to court where they can file a charge. It's usually 6 months. So that'll get the clock running. So if you don't want to get in a dispute that I didn't tell the person in time. failure to communicate, the failure to tell the person. The way the board is writing this, suggesting it doesn't matter whether it's a good or bad grievance. The arbitrary conduct, that they're saying is, we'll be more likely to find you acted arbitrary when you fail to communicate decisions, fail to keep the people advised as to the status of the grievance. And realize the grievant is probably going to look at this and say, look, I texted the person. I sent them an email, and they never got back to me. So the phone can help you too. You don't always have to have the answer. I know I get calls all the time and I don't know the answer right away, but I will text back, I'll get back to you, let me look into it. Keep the dialogue going, that you keep the person apprised. Your grievance is going to be heard on this date. If you have anything else I should look at, let me know. Return the calls, keep them informed. It's really informing the person, responding to that person. Now, they may be unhappy with the decision. They might not like that. Just say, look, we just don't think it's a good grievance, or we're going to settle it. That's no problem. That's not going to create a breach of the duty. What will create the breach of the duty is the fact that that individual will have a record, that he's chasing you down, and there'll be no response. That's what you got to worry for. So before I leave, on behalf of myself and our colleagues, Andre, Elizabeth, John, and Leslie, I want to thank all the international officers. We couldn't do what we do without your assistance. We rely on you, we rely on the local officers, and we appreciate the hard work you guys all put in because you make us look better. For me personally, I want to thank Dennis and Stevie. It's an honor to represent you guys when I go to court. I appreciate the trust you put in us, and I really think you make us better lawyers because we see your commitment and we want to work as hard as we can for you. So thank you very much. Have a great convention. And if you have any questions, please come up to us. Thank you.
Stay here for a minute.
Okay.